late December to respond to the motion to dispose of the complaint. I can definitely answer within that period. I'm okay with January 5th for the hearing, and if y'all would like to push it back to late January or February, I'm also okay with that.
Okay. Well, and I'll tell you what I'm going to do. In about, I'll look at my calendar real quickly here. What do we do in these cases? And what we want to do is we want to make sure there's no surprises. That's the way these hearings, civil type things are held. And so what I'd have to do is I'd have to have you have all of your exhibits and your witness list and stuff like that. But it's going to be really tight. By about the 12th, or excuse me, by the 19th, and then public service would really have to get it by about the 29th, which is kind of tight. That's a week away. I just think it's going to work a little better because just so you have everything right, I'm going to issue out a decision. It's going to get different things you have to have, numbering wise and stuff like that. And what I want to have is I just want, when we do have this hearing, I want it to run smoothly. I also want you to know what you need to do and how to do it so you can present your case best. Like I say, if we can move it back to the 27th, I can adjust those dates to you getting your stuff in by the, I'm going to say the 5th, and then if public service can get it back into by the 16th. As far as exhibits and witnesses, how does that sound?
Yes, sir. That sounds fine to me.
Okay. Like I said, I just want to make sure you're able to present your case in the best way that you want to. And also the public service can do what they want to too. And it's just a tight window with the motion to dismiss and Christmas and New Year's and stuff like that. So, okay. So you're okay with that. So when we say that, I'm going to go over some things and I'll re-go over this again. But sir, let me ask you real quickly if you have any questions.
No, sir, not at this time.
Okay. Mr. Aldo, do you have any questions?
Just to make sure that I'm following, or are we thinking there would be a process where Mr. Bordelon would, I'm trying to write down the dates, would submit his witness and exhibit list, and then we would have some time to submit ours just based on what he provides, and then we'd presumably get a ruling on the motion for summary judgment in advance of the scheduled evidentiary hearing. And I wasn't quite sure that I heard when we were thinking of scheduling that for, I know you talked about extending it out given the holiday, but.
Yeah. Okay. Yeah, no. I think you got everything pretty right there. Okay. So here's, and yeah, you're right. It's going to put me, I will definitely, I'm going to be off the week after Christmas, starting Christmas until the 5th. I'm off. I will, as soon as I get a response from Ms. Bordelon, I'll work on a decision on that to make sure. But so what I'm going to do is I'm going to have disclosures or filings, Mr. Bordelon, for you due on January 5th. And what that means, right now you filed a lot of stuff. And again, this is the stuff that I want to make sure that we get clear and why I want to have these pre-hearing conferences. Right now, the stuff that you filed is not in the proceeding. Okay. It's not in the hearing. Okay. I just want you to understand that real quickly. It can be. It's not saying it can't, but right now it's not. All right. And it won't be until we get to a hearing. And so what I'm going to do is I'm going to issue out a decision. It's going to have instructions on how to number your exhibits, stuff like that, what to do. The other side gets a copy of those before the hearing. They'll have to do the same thing too. And so you'll get theirs too. Okay. And those are the exhibits that you're limited to during the hearing. If there's something that comes up in what we call rebuttal, you can have that added. So again, Mr. Bordelon, if I say anything that doesn't make sense to you, please tell me and stop me, and I will go over this again. Because I'm assuming you're not an attorney. I don't know if you are, but if you're not, it's a new thing. So you'll do that by the 5th. They'll do it by the 16th. But those exhibits, when you have your hearing, I don't know how many witnesses you intend on having. You may be a witness, and if you don't even list yourself, I will assume you're a witness. It would not be a surprise to public service if you are a witness in this case. But someone out of the blue, suddenly they come in and you say, I want to have them testify. you're not going to be able to do that unless you give me a really good reason why you didn't disclose them earlier. When you do that, when you or your witnesses testify, all the exhibits that you have to enter into the hearing. So you'll ask for them to be admitted into the hearing. You'll have to lay down a foundation, what we call, just so I can prove, so I can know that where these came from, that they're authentic. At that time, when you move for that, I'll ask Mr. Aldo if she has any objection to that. If she has an objection, and this works for you too, I'll rule on that objection or allow it in. Again, public service will have to do the same thing with any exhibits they have. So Mr. Aldo will move to get it in. You can object. I will tell you, the one thing I can't tell you how to do your case. I can't do your case for you. The one thing I can do is I can try and interpret what you're saying in a legal form. Okay, so what I mean by that is I'm not going to require you to know words to say in order to have the objection. So the example that I always use, if Mr. Aldo suddenly says, listen, I'd like to bring in pictures from my prom at high school, and you go, I'm going to object to that, Your Honor. I really don't see why we need to have Mr. Aldo's prom pictures here in this case dealing with my electric bill. And I'll go, well, you know what, Mr. Bordelon, I agree with you. I don't think those are relevant. So relevant is the magic word that you're supposed to use for that. But however you put it like that, I'll try and interpret what you're saying. Another one could be, there's some bill that you don't know where it's from, and you go, well, I don't know where this is from. And if it's not properly that I can figure out where it's from, I'll lack a foundation on that, something like that. That all makes sense.
Yes, sir, it does.
Okay. And again, we're going to be in this. We're going to be in this environment. Those exhibits that you have, we have I have a legal assistant. I have 3 legal assistants, not all mine, but the commission does. And in these proceedings, what they'll do is you'll say, listen, could you put up exhibit 1 for me? And they'll be able to put it up on the screen. We'll be able to see it. You can also have a hard copy because from the public service ones, because they'll be required to send it over to you. So you could have it in both forms. You go through your case, you present your case, when you present your witnesses, when your witnesses are presented. If you have someone else, you ask them questions, they answer the questions. I'll try and keep it in a legal form. Like I say, if you want to testify yourself, you can, and just tell me what you want. Realize your witnesses and yourself will be able to be cross-examined by the other side. When they're done cross-examining you, I'll give you the opportunity with your witnesses or with yourself to do what we call redirect. And that's if you think that something got muddled in the cross-examination, you want to clear it up, you can do that at that point. That'll be it then. There will not be any recross or anything like that. You can do all your witnesses. You have the burden in this case. And when you're done, then public service does the same thing. They call their witnesses. You have the opportunity to cross-examine. They can redirect. And we might have what we call a rebuttal case if it's necessary at that. We don't normally in these cases. But then what will happen, I will tell you, I will not rule at the end of the hearing. The hearing will be over, and I will not say, okay, you win. We have to do everything in a written form. So I'll take it under advisement. I might ask for something written to be done at the end of the hearing, might not. Sometimes I do, sometimes I don't. And then hopefully within about 30 days after the hearing, then there'll be a ruling. Okay. And in the ruling will be, if you like the hearing, if you like the decision, then just sit back and enjoy it. If you don't like it, then will be ways in the decision will tell you how to, what we call file exceptions, which is an appeal with the 3 commissioners. All right, that makes sense.
Yes, sir. I have a couple of questions.
Sure.
Information that I want to present, if I download it from my account at the Excel Energy webpage, is there a process to get that authenticated, or do I just submit that as an exhibit?
I mean, I think you can tell me. I mean, I don't want to say too much how to do this, but I mean, if there's evidence that you have in it, you tell me where it came from. I will tell you, we're not incredibly strict in these proceedings and administrative hearings on exhibits, so it's not. It doesn't follow what I like to say is that we follow the rules of the Colorado Rules of Evidence unless we don't want to, unless there's a good reason not to. If you have that, you tell me where you got it, and I think Mr. Aldo will look at it and might have if she sees something really screwy on it, she might say, well, listen, I don't know why there's a picture of a monkey in the right-hand corner of this. I don't know if that's actually from ours. But as long as it looks legitimate, I don't think you can have a problem. Okay, so great. That'd be that's the best I can tell you. I mean,
Yeah.
I think you'll probably be okay, but as long as you can say when you got it, you know what I mean? So if you're using a web page, when did you get it? Where did you get it from? So forth.
Yes, sir. And if I wanted to obtain recordings from telephone interactions with Excel, is there a process to subpoena that, or is that possible?
No one's would call it become kind of a subpoena ducis tecum is what we kind of call it for kind of documents and stuff like that. I would not be. Again, I'm assuming I didn't ask you this. I'm assuming you're not hiring an attorney to do this. You're doing this yourself. And at that point, I can't get too far into what you can do. I think you talk to them and see what they can do if they can supply that for you first. That's what you want to do first, for sure. I mean, I don't know that they'll be mean and rotten and horrible. If you got a real problem with it, tell me. Oh, Mr.
Thank you, Judge Garvey, for having this pre-hearing conference. I think it's really helpful for us to kind of level set on what to expect for the hearing. But one thing that I wanted to raise on behalf of public service is that, we have been attempting to reach out to Mr. Bordelon for a while and try to talk this through and see if we can maybe resolve it amicably. And I do believe that this case in particular would be one where mediation would be very beneficial, and we just have not been able to, get a hold of. I believe I did talk to Mr. Bordelon's wife once, but I don't know if she ever relayed the message to us, and I don't think I have his direct phone number. And I think some of our agents had been emailing. Maybe it could promote efficiency for us to, be directed to participate in a mediation before the hearing, just to see if we can talk this out and resolve it, rather than kind of all of this process, if that can be avoided.
I could not agree with that more. I mean, again, I don't like to get too deep into the details of the case before I have a hearing. I don't want to prejudge in my head what's going on. But knowing the basic outline of what is involved here, I would agree with you. Mr. Bordelon, I will tell you that we offer mediation, and it's done by one of the other judges. So, and at least what I do, I don't know how other judges do their mediation, but let's say, for instance, I don't know what you're wanting, expecting, or anything like that. But if, for instance, I was doing the mediation in this case, I know it's a billing issue, and you said, listen, I want $10 million for how horrible they treated me during this time when they were billing me wrong. I would say, well, you're not going to get it. Okay, it's not going to happen. So get that out of your mind right away, and can tell you what things, whether the strength of your case, kind of what they see or what's on there. I don't know if you'd be interested in mediation. I think it's a great idea. I think in this case, I would 100% agree. I think this is a case that certainly could be figured out through mediation and talking to. So if you want to do that, again, if you want to do that, I don't know if we could do it real quickly here. Our problem is the holidays, and we could move back a little bit. So, Ms. Bordelon, what do you think about that?
My concerns go back to October. It's now December, and I know we're talking about a hearing in January. I don't want to derail that schedule. I'm happy to discuss my concerns with Mr. Aldo and Excel Energy, but I'm concerned that if I go down that path, then this entire process gets derailed. Is that true or not?
No, it's not true at all. It's if you go down that path, I mean, I'm not going to say it's not going to delay it a little bit. It might delay it a little bit. I might move it back I might move it back to a couple of weeks in February to allow you to try mediation, but it's not going to affect your ability or right. Or I mean, we can still go through with everything you're doing and have the hearing ready to go. Again, I mean, I always think the best path for. I mean, if we go to a hearing, someone wins, someone loses, and I have no idea who that's going to be right now. If you go to mediation, you agree. Maybe you don't get everything. I mean, I don't know. Maybe you don't get everything you want, but you at least get some on both sides. So I think it's worth seeing if there's a settlement to be made. It's not a waste of time. I don't believe at all. Again, I'll leave it to you. I'm not going to force you to do it, but I do think it would be. I think it could save you time, money, and effort.
Yes, sir. I'm willing to participate in that discussion. Again, I just don't want this to, be drug out unreasonably.
No. You know what I said? let me look real quickly. I have 2 hearings set in February. And so let me make sure that I don't get, let's see. Why is that on there? If we go to the 3rd, okay, so I'm just gonna make it a week later. Okay, we make the hearing on the 3rd. And there's some paper. I don't know if you guys want to talk now. I mean, seriously, just talk. There's nothing, and Ms. Bordelon, I want you to know this. If you come on the day of the hearing and say, listen, we got an agreement, I'm going to take it. I don't, we don't need to waste everyone's time if you guys make an agreement, do it at any time. And it does not affect, if you talk, it doesn't affect your ability. I will tell you one thing, anything you talk about in mediation, that's one thing I should mention. Anything you talk about mediation or any kind of talks, if you sit there and you mediate, doesn't work, or you talk, you negotiate, doesn't work, and if Mr. Geraldo goes during that negotiation, oh yeah, I know we're so wrong about what we did here, that's not admissible. Okay, you can't. Anything comes up in there, I'll stop you the second you start talking about, well, in mediation, they said, don't care, don't want to know, not relevant, can't come in. That's the only thing that's that way. I will see though about getting some paperwork for mediation to set it up. Hopefully we can do it fairly quickly. Sometime right after the 1st of the year. So, okay, so we're going to move the hearing to the 3rd. Again, Ms. Bordelon, your disclosures, and again, there'll be a decision that kind of describes what is needed in there. We do the 5th. Public service will be the 16th. Sometime, hopefully around there, you'll have a mediation that will be, there's five judges. So it'll be one of the other judges that will handle the mediation, because I can't. All right. Does it all make sense?
Yes, sir.
Okay.
Yes, Your Honor, I did just want to relay that if Mr. Bordelon wants to call public service or schedule a call with just us at any time, we're happy to do that outside of a formal mediation as well. The channels of communication are open. I genuinely believe that this case is just, there's some miscommunications and misunderstandings that I think if we could have a conversation that could really go a long way toward resolving this matter, given the nature of the issues.
Yeah, and again, Mr. Bordelon, I don't want to, I don't mean this to influence you one way or the other. But from what I have seen filed, and again, I haven't gotten too far into it, I would tend to believe that's the case. To me, this smells like there's a resolution there that should be able to happen. I thought that when I first got the case, I'll tell you that. But if not, I mean, I don't want you to tell you got it. You don't have to. You can come here, we'll have it here, and we'll figure it all out. By in no way or am I telling you to do one thing or the other. You do whatever you want. But I at the very least, I think it's worth finding out what they have to say. That can't hurt you. Okay, Mr. Bordelon, last chance. Anything else you want to talk about? Anything you want to say? I'll try and get, like I say, some mediation stuff to you guys today. Sign up for that. But and I'll get a decision probably sometime next week, which details out what you need to do. But you got plenty of time to get that done right now.
If I could repeat back what I've heard, there will be a deadline for me to respond to the motion to dismiss.
Yeah, that's going to be at least as of right now, it's going to be what I say that was filed, I think, on 2 weeks after it was filed. I'm assuming you got it on the 9th, so it's going to be the 23rd. I say, if for some reason you need more time, please tell me. Again, I'm not going to. It's right at Christmas, so I don't know if you're going out of town. If you're going out of town, you don't get it done. Something. Shoot me a quick file and say, please, Your Honor, talk to them. They might not have a problem with it. I doubt they will. And you get more time. But as of right now, it's due the 23rd. By the end of the day, on the 23rd.
Okay. Yeah. And then, assuming that the case is not dismissed, then there will be a hearing scheduled. It sounds like the first week of February.
Right.
And then I have the option to enter into mediation or in discussions with Excel. And if we resolve it, great. If not, then we'll go forward with the hearing.
Yeah, I mean, one other date you need to keep in mind, or two other dates you need to keep in mind. One is the 5th of January, and on that date, and again, in this decision will outline it. You need to file all of your exhibits, even if you filed them already. What you plan to use in the hearing, and any witnesses, a list of witnesses you have to have. Public Service will do the same thing on the 16th of January. I will also say you don't have to wait till a certain point in time to talk to Public Service. You can talk to them, as soon as we're done here, you can talk to them right after that. And the sooner you get this resolved, the less of the stuff you have to worry about. So, so you can talk to them from now until 9 a.m. on February 3rd, as far as I'm concerned. At that point, you talk to them even after that. They're going to start during break, but probably don't want to do that. But okay. And like I say, it's going to be on this forum. It's going to be the same thing on Zoom. And the technical stuff will be done by our court legal system. So, Mr. Aldo, got anything?
Nothing further from Public Service.
Okay, Mr. Bordelon, last chance.
No, sir, nothing further.
Okay, thank you all. Have a Merry Christmas. Have a good holiday season. I'll see you after that. And again, look for stuff from me coming out sometime either today or first next week. All right. Thank you very much.
Great. Thank you, Your Honor.